What I'm going to be talking about, and I'll be talking again about the waiting period because it applies to large employers. The employer mandate introduction, I'll be talking about what is a large employer, because I've talked to and helped many employers trying to decide how to determine being a large employer status. And there are rules, the fact that you have to follow to determine that. The most important question is, what is a full-time employee? I'll be talking about that. I'll be talking about the penalty taxes. I'll be talking about the notice of premium assistance. And then lastly, I'll be covering very briefly the reporting of coverage, which is going to be extremely important. The waiting period, remember, effective for plan years beginning in 2014. The waiting period cannot exceed 90 days. It only applies to medical. It doesn't apply to something called accepted benefits, which is dental and vision. Grandfather plans also must comply. Now, one thing they added to the regulations that came out last year, as an employer, you could impose a 30-day orientation period before the 90-day period starts. So it's going to be, if you wanted to, it could be close to 120 days before any full-time employee would be eligible to actually participate in your plan. So waiting period is the period that must pass before an employee dependent is eligible. The cumulative service requirement is in there in case you want to make a requirement for part-time employees. But in this situation, you count all calendar days, including weekends and holidays. These are examples how this works. The group health plan provides a full-time employee with coverage. This person starts on January 19th. Let's say it's that employer is subject to it. That employee would have to be eligible on April 19th, assuming that February has 28 days. Another special exception, if you have certain training and certifications to be eligible, you can impose that. Lisa was hired on May 3rd, meets the plan's eligibility requirements on September 22nd. The 90-day period starts not on May 3rd, but September 22nd. That's when she meets the plan's eligibility requirements. Remember, if you had a long period of time as your eligibility, remember the plan's condition is based solely on lapse of time, and it cannot exceed 90 days. So as that plan year starts in 2014, it must switch over. And basically what illustrates that is example 4. Sarah starts with the company in 2013. They have a 6-month waiting period. All right? As soon as the 2014 plan year starts, she has to be eligible because now the waiting period translates from 6 months to 90 days. And since she already has 93 days, started their plan year in 2014, she would have to be eligible. I've gotten tons of questions, and that's why that example is there. Yes?
What if you have a late enrollee provision in your plan? You can't wait more than 90 days for that either, can you?
Give me an example of how your plan works.
So if you enroll within the first day, and you don't do that, but then you decide to come back on, so they would have that in the past. A lot of them we see, they had to wait 18 months rather than the 12 months. May have been required for initial enrollment.
I've not seen any provision in the law that talks about special other late enrollment situations. I don't think it applies. So I've not seen any discussion of other regulations on that. All right? Now let's look, just do an introduction of the employer mandate. Beginning in 2015, certain large employers have to be eligible. And you can be penalized if you don't offer coverage to the employees, or if the coverage is not affordable and not minimum essential coverage, which is at least 60%. And the penalty tax is due if any full-time employees is certified to the employers having purchased health insurance on the exchange. Now, this slide is extremely important, but it's also very confusing. If you are a large employer, 100 or more, basically the employer mandate starts on January 1st, 2015. The only exception to that is if you have a non-calendar year plan. And basically, what this slide says, the government says to you, we're going to force you to jump through some hoops. And basically, what this slide says, as of any date within 12 months of February 9th, 2014, did you offer coverage to enough people, or did you cover enough people? All right. First of all, relief if coverage is offered to at least 1/3 of all employees or 1/2 of full-time employees. And that's of any date within 12 months of February 9th, 2014. Or did you cover at least 1/4 of all your employees or 1/3 of your full-time employees? If you meet one of those two requirements, then you can use your renewal date. If you can't meet that requirement because you didn't cover enough people in the past, then you have to comply as of January 1st, 2015. So extremely important to understand. These are the hoops you have to jump through. So first of all, you have to look at your last renewal, your last enrollment before February 9, 2014, and did you offer coverage to enough people? You can either use 1/3 of all employees or 1/2 of just your full-time employees, and that definition is 30 hours or more. All right, so did you offer enough to enough people, or did you cover enough people? You had to cover at least 1/4 of all employees or 1/3 of your full-time employees to do that. So the last two safe harbors will be available if you offer minimal essential coverage as of your 2015 plan year. But in all cases, an employer can determine the percentage of covered employees as of the end of the most recent enrollment before February 9th, 2014. Now, first of all, many employers are going through this, and I've gotten a lot of conversations with clients about, am I a large employer? And this determination is extremely important. Now, this is done on a control group basis. What is a control group? A control group is basically we base that on ownership. And there's three types of control groups. There's parent-sub, where the parent owns at least 80% of the subsidiary, or it could be brother-sister, which means 5 or fewer individuals own at least 80% of each entity, or it's called an affiliated service group. These are for professional firms. And do you provide services to other companies? If you meet one of these rules, that means all the different companies that you control, they are considered to be one employer. And so for the employer mandate purposes, all the other companies that your employer controls would be considered one. Now, your accountant or your attorney should tell you whether you're part of a control group. But that's an extremely important calculation. You should know this already. I'm surprised how many people don't know this, because it is used for non-discrimination testing for your 401k plans. It's also used for non-discrimination testing if you're self-insured. So this has to be, so the employees of all employees within the control group are taken into account in determining whether you're a large employer. Now, so for this purpose, for 2015, a large employer is anyone who has at least 100 full-time employees in the preceding 2014 year. So we always determine your status in the previous calendar year. So for 2015, we do this in 2014. Now, it's basically an average over 12 months. But for 2014, they've created a special exception. And you can determine it over any consecutive 6 months to determine how many employees. And this is going to be extremely important, because if you get under 100, you may delay the employer mandate for another year. So this is an extremely important calculation. So in determining the number of full-time employees, an employer must add up the total number of hours worked by the part-time employees, divide by 120, and add that number to the number of full-time employees. For this purpose, a full-time employee is defined as anyone who works 120 hours or more. So for each month, each employee's hours are counted. If you have part-time employees working for you, you total up the number of part-timers, divide by 120, and that gives you a full-time equivalent employees, and you add the two figures together for each month. So a full-time employee for any month is an employee who is employed for an average at least 30 hours of service per week. Now, for 2015, if you're between 50 to 99, you have another break, because with the regulations they came out in February of last year, they said, okay, if you have 50 to 99, you can wait until your renewal date in 2016 to comply, but you have to jump through these hoops that you see there. First of all, you only have to have 50 to 99. You must maintain your workforce and not get rid of people because of the mandate. And any previous plan that you have, any plan that you have to keep in place all of 2015. You can't get rid of it, or you can't change your plan year. Now, I asked the IRS recently, I said, I have a client who's between 50 to 99 and has never offered coverage. Can they take advantage of this? And the IRS said yes. But they must comply as of January 2016. But in this situation, if you comply, you don't have to comply to your renewal date in 2016. And lastly, what you must do is file a certification with the IRS. That certification form has not been released yet. We don't know what it's going to look like. Probably it's going to be attached to your tax return for 2015. So in determining who's full-time, part-time hours are taken into account. The number of full-time equivalents the employer employed during the preceding year are taken into account. And all employees, including seasonal, which were not employed on average at least 30 hours, are taken into account in this situation. So instead of full-time equivalent employees, you calculate the aggregate number of hours per month, and then you divide the hours by 120. So all part-time hours are put together, divide by 120, that gives you what's called full-time equivalent employees. Then what you do, you calculate the number of full-time employees for each month, you calculate the number of full-time equivalent employees, add the two numbers of the full-time and full-time equivalents together for each month, and then you divide by 12. Now, as I indicated before, they created a special exception for 2015. You can use any consecutive 6-month period to make that determination. I just helped a nursery, and it's surprising with the nursery, certain parts of the year they have 12 employees working for them. In other parts of the year they have 200. So if they can get rid of, again, seasonal employees or certain people, because there is an exception. This is the transition rule I just talked about. So you can use any 6 months. I used the 6-month period, the beginning of the year, January through June, and they didn't have that many people. Now there's another exception, which is explained here, which I started to explain. I realized I didn't explain it yet. There is a special exception for seasonal employees. This is explained. So if you have a seasonal business, and you generally employ 30 people during the year, but during the summer or during Christmas, you have an explosion of employees. And this is for a 120-day period. So for a 120-day period during the year, you have seasonal employees, and because of them, you get over 100. Those seasonal employees can be excluded from the calculation. So in my example, if my employer usually employs 30 people year-round, but for 120 days during the year, I hire a bunch of people. I run a pool, I run a ski lodge, I run all kinds of other things, and I only use people, seasonal employees, for 3 months, or 4 months, excuse me. If that's the case in that situation, for the large employer calculation, those seasonal employees can be ignored. Now remember, there are 2 penalty taxes that you have to concern yourself with. One is if you don't offer coverage. All right, that's the $2,000 penalty. And you only are penalized if you don't offer coverage to at least 70% of your employees. I'll go through this again. So in order to avoid the $2,000 penalty for 2015, you have to offer coverage to at least 70% of your full-time employees. So you can avoid the $2,000 penalty if you do that. The second penalty is if you offer coverage, the coverage must be affordable minimum value coverage. and that minimum value must be at least 60%. So there's no requirement here that be minimum value here, but there's minimum value here. And it's 9.5% of their wages. So any premium they pay for individual coverage cannot exceed that. Now, the most important question you have to ask yourself, especially if you have a certain number of employees, who are your full-time employees? And especially if you have people that work various parts of the year, they work, depending on the time of the year, they work various hours. Basically, you have to determine which of those employees are deserving of coverage. So for determining penalty, a full-time employee is anyone who works on average at least 30 hours. The full-time status is easy for those employees who work 30 hours a week. But again, what you must do in 2015 is divide your employees in 3 different categories: full-time, part-time, and variable hour. For a variable hour employee, these are part-time or seasonal employees that work various parts of the year. In some parts of the year, they may work 30 hours. In other parts of the year, they work 10 hours. In other parts of the year, they work 40. So what the IRS has done for you is created a safe harbor for you. But you have to first determine who is an employee. For counting hours, we use the common law standard, which means, are they your employees? Are you giving them a W-2? Or are they a 1099 employee? Those are technically not employees. They're independent contractors. So please be very careful. And you also have to be careful with temporary employees. I advise a lot of employees to use temporary employees, and they're coming very close for these employees to become your employees, because I had one situation where a temporary employee from an agency has worked there for years. And my general rule is you only want to use a temporary employee for at least 6 months, and then you should change. Because the longer that they're there, the more control that you exercise over them. You don't differentiate between that temporary employee and your other full-time employees, and it's real dangerous. But when you're determining how many hours they work, basically for hourly employees, you actually count all hours they get paid for: vacations, holidays. For any non-hourly employees, must choose 1 of 3 methods. 1, you have to count all hours that they work. And in some situations, it's extremely difficult, especially if employees are paid per diem, if they're paid per mile. It's going to be horrible to do this. Now, if you don't do this, the DOL, the Department of Labor, has created 2 different categories. One, if somebody has worked if somebody has worked a day for you, they're deemed to work 8 hours. If somebody has worked a week for you, they're deemed 40 hours. That's really generous. And what they've indicated, if you know your employees don't work 8 hours, they work 10 hours, you can't use this. Or if you know your employees work 60 hours, you can't use the 40 hours. Now again, all hours include all paid leave. They include vacations, holidays, leave of illness, disability, or incapacity. It includes any paid layoffs or jury duty or military duty. Anything you pay for is counted as an hour of service. Now, in order to determine whether you're, who is full-time for this purpose, the IRS has created 3 safe harbors. One is based on a monthly basis. You determine their status every month. And if they work 130 hours, they're full-time, so you have to offer them coverage within 3 months, which is very disruptive. The others use what's called a look-back method, where you use one period for new employees and another period for ongoing employees. All right? Now, I just have to warn you, these safe harbors are complex, and they both rely on defined time periods that generally must be measured in a uniform fashion for all employees. Now, under the monthly method, employees will be identified full-time for initial eligibility using their hours of service for each calendar month and not based on averaging over the look-back period. So basically, you look at what their service is for a month, and if they work 130 hours, then you must offer them coverage after 3 months. But you have to, it's a rolling period, so some months they get coverage and other months they don't. The other is the, what I like is the look-back period. Basically what you do, you create a 3 to 12 month period and you see how many hours they work. Now if you use a 12-month period, that means that person must work 130 hours times 12 or 1560 during that 12-month period. Now what's important to understand, while you're measuring them, they don't get any type of coverage. And in this situation, if you designate someone as a variable hour employee, they don't get coverage for a period of 15, 16 months while you're measuring them. Because there's a 12-month look-back period and then a 3-month administrative period. So that person could wait a long time to get coverage. But you only measure those employees that are variable hour. And when they are hired, you have to designate person as either a part-time, a full-time, or variable hour. And you have to measure those employees that are variable hour. Now I get a lot of questions. Suppose I hire somebody as a variable hour, and let's say they start working full-time hours. What do? You have a choice. Either you reduce their hours and have them fluctuate, or you do a change in status. And now instead of being a variable hour employee, they are now a full-time employee and deserve coverage. So please be extremely careful. You can't just set it and forget it. Because I've advised many fast food restaurants or other restaurants where they hire somebody, they really work out well. And all of a sudden now they look at the schedule and that person's working 30 hours a week. And the HR person has to ask, is this person really full-time now? And so they have to look back and see exactly what they are, because the definition of variable hour employees, their hours will vary. Well, if they're always working 30 hours, they're not variable hour anymore, they're full-time. Now the stability period, you'll see the stability period, that's the period that you offer them coverage. So whenever you have to comply with the employer mandate, it's the start of your first stability period. So it's either January 1st of 2015, it's either your renewal date in 2015, but that's when you have to offer them coverage. And if you use a 12-month measurement period, then basically what you have to do a 12-month stability period. Now one thing that's important in this is that once that person gets coverage, you offer coverage and they take it, no matter what their hours are during the stability period, you have to continue to offer them coverage. So even if they're working 10 hours a week, they're still eligible during that stability period. Now, any employees who failed to meet the minimum hour threshold during the look-back period do not have full-time status during the stability period and will not trigger any responsibility. So the stability period can't be short in duration, the number of months, and the associated look-back period. If an employee meets the minimum hour threshold during the look-back period, then the ensuing stability period must be at least 6 months. The one disadvantage, and some employers ask me, well, suppose I use a 6-month measurement period. That means the stability period is 6 months, and basically what you have to do, you have to remeasure twice a year. That's going to be a nightmare. Now, in between the measurement period and the stability period is your optional administrative period. It can be any period up to 90 days. And basically that's your enrollment period, that people enroll in your coverage. So if you don't have that many variable hour employees, you may take, instead of taking 90 days, you may take 3 weeks or a month to offer them coverage. But the period can be up to 90 days. Now, it must be uniform, and an employer generally must apply a selected look-back period on a consistent basis, but you can vary it between collective bargaining, non-collective bargaining employees. Employees in various states can have different measurement periods because you may have different effective dates for your coverage. Now, the first safe harbor is called an ongoing employee. This applies to any employee who's worked for you for at least a year. That means all employees are measured together. This is called the standard look back and stability period. And in this situation, what you have to do is you have to make sure you know what your renewal date is, have the administrative period a few months before that stability period, and then your measurement period ends just before that. Now, you can, again, look back period and stability period selects apply on ongoing employees are standard. You pick it, all ongoing employees are measured at once. And then again, you have the optional administrative period. Again, that can be as much as 90 days. Now, here's an example. Suppose this employer had to comply as of 1/1/2015. All right? Their standard look-back period is from 10/15/2013 to 10/14/2014. The administrative period is from 10/15/2014 to 12/31/2014. And then the standard stability period is from 1/1/2014 to 12/31/2015. Now, if that employer doesn't need that long of an administrative period, that standard measurement period could actually end sometime in November. But again, you have to make sure and you're measuring during this period of time. Now, a second look-back period, and this makes it really complicated, for any new employee, they get their own measurement and stability periods. So again, for any new hires, if you hire someone and they are determined to be variable hour, they get their own measurement and stability periods. So there's a separate initial look-back measurement and stability periods, different from the standard stability period. But it doesn't apply to any employee that is expected to work full-time. You don't measure full-time employees. So if anybody is expected to be full-time and you designate them as full-time, then basically what happens is that 90-day period applies and all this I've just talked about doesn't apply. All right? Now, the initial look-back period starts either the beginning of the month after their hire date or their hire date. So every new variable hour employee gets their own measurement and stability periods. There are several limitations on this. The initial look-back measurement period, administrative period, can exceed 13 months, so the period is shorter than ongoing employees. New employees' initial stability periods can't be shorter than the standard stability period. So in operation, if you use a 12-month period for ongoing employees, you have to use 12 months for new employees. So once an employee has completed the initial look-back period, then they're put in the standard measurement period, and I'll be discussing and showing how that happens. Starting with the standard look-back period, the employee's full-time status is determined at the same time and using the same conditions as ongoing employees. Now, if the employee fails to meet the full-time status during the initial measurement period, both conditions apply. The stability period can't be shorter than 1 month longer than the initial measurement period. If the employee meets the full-time status during the overlapping or ensuing standard measurement period, they have to be treated as full-time and full-time during the standard period. Now, here's how this works. We have a situation where we have a variable hour employee. You have a 11-month initial measurement period followed by a single administrative period. Jim is hired at 5/10/2014. His initial measurement period runs from 5/10/2014 to 4/9/2015. His administrative period, where he signs up as 4/10/2015 to 6/30/2015. His initial stability period is from 7/1/2015 to 6/30/2016. That's individual for each employee. Now, the problem with that is your company has a lot of variable hour employees. You don't want to use this because you could have a number of measurement periods that you're trying to keep track of during the year. Now, what happens, okay, Jim decides he's going to take coverage. He has coverage during the initial stability period. As of 6/30/2016, we look back as Jim is full-time during the standard measurement period from 10/15/2014 to 10/14/2015. All right? If he is, then it gets coverage from 7/1/2016 to 12/31/2016. All right? And at the end of 12/31/2016, we go back to the next standard measurement period, and then we measure again. This is going to take a lot of work, especially if you have a lot of variable hour employees. Now remember, in order to avoid the employer mandate in 2015, you have to cover 70% of your employees. That requirement goes up to 95% in 2016. So this year, you can be a little sloppy. Next year, it's going to be extremely important to capture every employee that's going to be a variable hour. Now, this is a slightly different example. Here we have a situation, we have a 12-month measurement period, but again, we measure it as of Sam's, not as of his hire date, but the beginning of the month after the hire date. So we have a short administrative period here, we have a very short administrative there. The stability period is the same, and in this situation, then he gets coverage at 6/30/2016. If he's still there at 6/30/2016, the employer has to look back and see if he's full-time during the standard measurement period. Okay? Are there any questions so far?
More of a comment, I think.
Oh my God, no.
It appears to me that it would be in our best interest, if at all possible, to not have any variable hour employees. Correct?
Yeah.
Okay.
But in your situation, I advise a lot of schools, and you have substitute teachers. You have people that, for various parts of the year, work various hours. Okay, they may work during a season, during a school year, and then the next school year work hardly at all. So I don't think in a school you can avoid it, especially if you have substitute teachers. Or you have people that are substitute teachers and are coaches.
But substitute teacher can only teach up to 100 days.
Okay.
So if we've got a year-long look-back period,
That's not going to, yeah, they won't be full-time, but it's suppose they take a permanent position, or suppose they're substituting for somebody during a semester. Is that possible?
I mean, they can still, their certification only allows them to do 100 days.
Okay, okay. But again, certain industries I've advised can avoid this. Hotels, restaurants, temp agencies. There's all kinds of businesses that rely on variable hour employees because they have a seasonal aspect to it, or they have certain various projects. Sometimes I've seen businesses that staff up at certain parts of the year. So again, if you have variable hour employees, this is going to be extremely important. Now, also there's special rules for unpaid absences. If you have people that come and go during the year, and this is extremely important. So if they're gone 13 or more weeks, when they come back, they're treated as new employees. So if you have people that work at certain parts of the year, now for this purpose, a seasonal employee is defined as anyone who works 6 months or less for you. So if you have somebody that's a seasonal employee and they come back every year, but the absence is 13 or more weeks, when they come back, they never get coverage. Never. They're always a new employee. So under this rule, if their absence is 13 weeks, when they come back, sorry, you're a new employee. Now, if you don't like this rule, there's a second rule. Well, and again, for the rule of parity for schools, that absence is 26 weeks. So an employee rehired after terminating employment may be treated as a new employee if the break in service is at least 4 weeks long and exceeds the... Now, the other is the rule of parity. Instead of using the 13-week rule, you can instead use the rule of parity. And basically what that says is an employee rehired after terminating employment may be treated as a new employee if the break in service is at least 4 weeks long and exceeds the employee's period of employment immediately preceding. So if that person works 4 months for you, is gone for 5 months, When they come back, they're treated as a new employee. Now, also for unpaid absences, such as family medical leave, jury duty, military leave, or uniform services, USERA leave, you have a choice of either excluding leave, the time that includes the leave, or crediting services during the leave to count whether they're full-time or not. Now, again, what you have to do, you have to start measuring hours. You have to, if you have to comply in 2015, you have to start fairly early, especially if you have to comply as of January 1st, 2015. So basically what you have to do is currently record records. This may be simply sharing already captured payroll or workforce management data. But again, you have to set a strategy so you can measure. You may think about this, employers with large numbers of short-term employees may look at shorter periods, especially if your turnover is very great. But when designing a healthcare strategy, in most situations I've found, a 12-month measurement period is the best. Now, there is, again, a special transitional rule that says that for 2015, which you can use a 6-month measurement period with a 12-month stability period, which is generally verboten. But again, you can do with that as long as that plan year, at that measurement period starts no later than July 2014. So these are the steps you have to take. You have to decide exactly how you're going to do this. You have to consider the safe harbor approaches, determine optional measurement and stability periods, amend your plan documents, and communicate what you're doing. The penalty taxes, again, there's 2 penalty taxes. Again, the penalty taxes only apply to full-time employees. That's what you have to concern yourself with. So again, either applies in the calendar year or the plan year. Again, this is the first penalty, the $2,000 penalty. Again, to avoid this penalty in 2015, you have to cover at least 70% of the employees. If you're subject to this penalty, it's $2,000 for each full-time employee minus the first 80. In 2016, it will go down to 30 employees. The 80 reduction is applied on a control group basis that you see here. Again, what this slide is trying to tell you, the fact that you have to offer coverage to at least 70% of your employees in 2015. Now, also what you have to do, you have to offer coverage to your full-time employees and their dependents. A dependent is defined as your children. You don't have to offer coverage to the spouse, so that's what that slide is trying to indicate. If you do offer coverage, please make sure that coverage must be affordable, minimum central coverage. If you're subject to this penalty, it's $3,000 per employee. There's no minus number, but you're never penalized more than if you didn't offer coverage at all. That's the cap. So again, you're only penalized in this situation if the employee actually goes on the exchange and gets a credit or subsidy. In order to avoid this penalty, you have to meet these 2 tests. It must be minimum value, and it must be affordable. Affordability, what they've done is they created 3 different safe harbors. You can use the W-2 safe harbor, which is based on current W-2 wages. The rate of pay, you pay someone plus times 130 hours, or the federal poverty line, which is currently $11,770, which is very generous. So you apply 9.5% based on that. Again, it must be minimum value. If anybody's union here, what these slides are trying to tell you is you don't get out just because you have a union plan. You have to make sure your union plan is actually affordable minimum central coverage. You have to talk to the union about that. There's no exception for union employees. Union employees are also counted for the large employer calculation. So again, each participating employer is responsible for identifying full-time employees and then make sure the coverage is affordable minimum central coverage. Extremely important. What happens is if any employee goes on the exchange and gets a credit and subsidy, you're going to be notified of that. All right, so you're going to be, again, notified of any coverage. So when the exchange determines the applicant is eligible to receive advance payments of premium credits and subsidies, they will notify the employer. This notice will include the employee's identity, that the employee has been determined to be eligible for advance payment, and the employer may be liable for a penalty. The IRS will then contact the employer to inform them of their potential liability and provide them the opportunity to respond before any liability is assessed. You can say, hey, we offered them coverage. Here's the evidence. They waived it. The most important form in 2015, if you offered coverage and the employee waived it, is a waiver form. Because the employee will say, well, they never offered me coverage. Where's the evidence? A waiver form is extremely important. But again, the first time you're going to be contacted by the IRS won't be until sometime in later 2016, probably next summer. If it is determined the employee is liable for a penalty, the employer has responded to initial IRS contact. The IRS then send a notice and demand payment. This notice will instruct the employer of how to make payment, and the employers will not be required to include the payment in their tax return. Now, we talked briefly about the reporting requirement. This requirement is for 2015, filed in 2016. There's two requirements, one under 6055, that's for small employers, and then there's one under 6056, is for 50 or more. So the IRS for 2014 published final forms and instructions. And get familiar with the forms 1095C and 1094C. That's what you have to do. So again, now there's good faith compliance in 2014, which means you don't have to do it. You can do it, but you're not required to do it. So the applicable large employer who employs 50 or more in 2015 has to file these forms. It's not 100, it's 50. So if your company is subject to the employer mandate, it must file a required form and furnish a copy to each full-time employee. To report the employer responsibility purposes, the plan can use a plan administrator to file on behalf, but a large employer member remains liable for the reporting. So there are these forms. There's a 1095C, will be used for self-insured employers, will also be used for insured employers. Certain sections have to be completed by insured employers and other sections by self-insured employers. For small employers, they'll have to do a 1095B. This is the, where you can get a copy of each of these forms. Again, the 1094B is for the insurance company to provide evidence of coverage. The 1094C is the transmittal form. The 1095A is for the exchanges. Don't worry about that. The 1095B is, again, that's for small employers. And the one you have to worry about is the 1094C and the 1095C. That's something you as an employer are going to be responsible to filing, and the purpose behind it is threefold. One, these forms are going to, again, evidence who has coverage. Two, is for the employer mandate. You're going to tell the IRS who you offered coverage to and when. And three, is to give evidence to the IRS who is eligible for credits and subsidies. They're going to use these forms for this purpose. So again, you can do it electronically or you can do it through paper. The time tracks are similar to W-2 forms. If you're doing it on paper, it's February 28th. If it's electronic, it's March 31st. And this is 2016. A copy must be provided to employees by the end of January 2016. There's penalties if you don't do it. It's $200. $100 if you don't file it, and another $100 if you don't provide it to the employees. Are there any questions? As the old joke goes, so Mrs. Lincoln, how was the play? This 1095C, and again, only for that part of the presentation, In order to explain the forms, I have 64 slides. So it's very complicated. This is going to be the IRS's window to penalize you, so you have to get the information correct. It's extremely important to understand that.